Unless you've been living under a rock, you've likely heard about the non-compete ban that was proposed by the FTC. Well, here's an update on whether it applies to physicians or not. Welcome to the Money Meets Medicine podcast, where we talk all about the personal finance topics you wish you'd learned in medical school. I'm your host, Dr. Jim Turner, and this episode's guest host has had 2 hole-in-ones despite not being a very good golfer. Kyle Clausen. Kyle grew up in Pipestone, Minnesota, where he received his undergraduate degree from North Dakota State University, went on to get a law degree from the University of Laverne College of Law, and an LLM in taxation from Boston University. Kyle is an American Health Lawyers Association member, and importantly, he is a physician contract and compensation expert specializing in educating and advising physicians on the legal, financial, and strategic aspects of employment agreements or contracts, which we're going to discuss in this show. Kyle's got more than 10 years of experience representing physicians and has negotiated with major health systems, private practices, and academic centers. He's also the founder of Resolve. Before we get to that, I want you to know about a partnership that we've created at Money Meets Medicine with Resolve, because I'm a big believer that every physician who is looking for a new job or is considering a different job needs to get their contract reviewed before they sign on the dotted line. I've seen way too many doctors who didn't do this and then ended up finding about a non-compete when they tried to leave their job or found out that their tail insurance wasn't covered. A lot of the things we're going to talk about specifically on this show. So for this reason, Money Meets Medicine has partnered with Kyle at Resolve, his company. And at Resolve, they can provide not only contract reviews, but also data plans where you can see real contract information from actual contracts from other doctors. So if you want to get that data or have your contract reviewed, you can go to moneymeetsmedicine.com/resolve and use the code 10OFF, 10OFF, that's 10 off at moneymeetsmedicine.com/resolve. That will get you 10% off of any of the package that they offer there. All right, let's get to the show. Kyle, welcome to Money Meets Medicine.
Hey, thanks for having me.
Absolutely. I got to hear about this hole-in-one story. There's the 2 hole-in-ones. I play a lot of golf. I'm not very good at golf myself, but I used to play a lot of golf. I've never had a hole-in-one. So what's the story here?
So, I've got 2 hole-in-ones, and I'm not very good at golf either. So that's what makes it so fun is, you can hit a really big slice, and sometimes it'll still just kind of drop right in there. So one was about 10 years ago, and one was about probably 5 years ago. And the most interesting fact about this is I was playing with a guy that I've only played with twice. And so he's seen both of my hole-in-ones.
Yeah, what are the odds of that? That's insane. Oh, man.
Yeah.
Well, hey, so Kyle, I really want to have you on the show, and I think this is good timing because there's been some recent events in the last month or two as we're recording this. But for those that aren't familiar, the FTC, the Federal Trade Commission, they implemented this like sweeping ban. It was going to come into effect September 4th. We're recording that within a week after that. They proposed this rule about non-compete clauses, and all the doctors and all of the hospitals, of course, heard about this because many of us have non-competes. So it was supposed to go into effect. It didn't go into effect, and there have been a couple rulings on this. So why don't we just back up and get the big picture laid out for us, how this went down and where things are today?
Sure. So the big history, right, of non-competes is historically there was no federal national regulation on this stuff. It was just every state has their own rules on what you can do and what you can't do. The FTC came out with a rule that said we're just going to ban them all together, right? We think it's an unfair restraint on trade. It's bad for low-income workers. It's also bad for people like physicians. And so the rule came out. The FTC only can regulate for-profit entities, so there's automatically some limitations to what they could do and couldn't do. And that got passed earlier this spring. And so we've been in this waiting game from spring until now. And, as you would expect, right at the very last, couple weeks here, there's been challenges to the FTC. And so right when you thought this thing was going to go in place and all the physicians were going to be, no handcuffs on them anymore, the courts came out and said, hey, you can't do this, right? We're going to put a stay on it. And so now the FTC has to decide if they're going to appeal that or not. And whether they do or they don't, there's really no solution today, right, on September 9th when we're recording this. For physicians, you've got to still kind of be stuck or be careful on these non-competes in your contract. So yeah, it's an ever-changing landscape for physicians out there right now, and we're hopeful that there's going to be some type of ban, whether it's locally or nationally, but as of today, there's not.
Okay, and so I'm obviously not a lawyer. So there's a ruling in Texas that basically says, hey, we're going to stay this FTC non-compete that the FTC put in place. And then there's this ruling in Pennsylvania that says, hey, we're actually kind of okay with this. So in the legal world, like state of Texas, state of Pennsylvania, it seems like those should be state decisions, and yet they have, it seems like federal consequences or federal implications. How does it work when you have two different states have two different opinions on a FTC federal?
Yeah, so there's state court systems and there's federal court systems. So these are two different federal courts, right? And so what happens on any issue like this, because it happens all the time, you just keep working your way up, and so that they're going to appeal it. And where do you appeal it eventually? Is maybe the Supreme Court, right? I mean, eventually it might get to that spot. We know that that's not quick, right? That's not going to be a hey, find out in October type of thing. It's going to be 2025, 2026. I mean, somewhere down the line where they'll make a decision on it. But the good news on this, and I do want to make sure we talk on this. It's gotten so much attention that, and especially for physicians for healthcare, a lot of the states now are moving. So historically, it was like 3 or 4 states that had some bans on this stuff. Now there's 20 plus that have either passed some limitation and or have pending bills that are going to help on this topic. So I think overall it's still a net positive, right? For physicians, it's just not as maybe as sweeping as we want it to be.
Yeah, I think it'll be interesting to see how different states handle this. And I know that there have been some arguments, at least there have been some huge non-compete things that have happened in my state, North Carolina, actually in my own specialty. And so, where hospitals had contracts with large private equity or large corporate established relationships, and then they basically said, hey, we're going to just get rid of your contract. And then all the physicians who maybe did or didn't realize it that were employed by that large corporate entity now live in a city that they no longer have a job.
Yeah.
And so the non-compete was still upheld in that situation, despite the fact that they still lived in that city, the hospital was still there, but because they're employed by that large corporate entity, they basically were out of work.
Right.
And it was really interesting at the time because a lot of people, and this may not be true, but word on the street was that if you had ever challenged it, like if you ever had the amount of money that you would need to challenge that non-compete, that it basically would not have been upheld. But because of the financial burden of what would happen if you went through that process and you were wrong, most doctors have never pursued that, at least in the state of North Carolina that I'm aware. Is that just like folklore, like wives' tale, that if you were to fight this thing that it would actually be fightable, or does that have some truth to it?
No, it has a lot of truth to it, but I think the economics are what prevent people from doing that because they don't want to risk, $40, $50, $100,000, right, on fighting something to then lose. But so non-competes generally, they have to be reasonable on time. So how long post-employment, right, can you be prevented from working? They have to be reasonable on scope. So if you're internal medicine, is it outpatient or is it inpatient only, right? There's some scope distinctions of what can happen. And then finally, it's got to be that radius, the geographic area. All 3 of those things have to be reasonable. And so if your situation that you're talking about, if a court would say, hey, the geographic scope on this thing is not reasonable, we're going to strike it from 50 miles to 10 miles or whatever the example would be. I think there's a really good chance on that in certain situations, what your specialty is, what the radius is, right? I mean, you never know until you look at the facts, but it is a pain in the butt to go through that process. And so our advice, right, and what we do at Resolve every day is look at these contracts before you sign them. We're like, let's just solve it right now. Whether a law comes out and bans it later or whether you'd win in a court battle later on, we don't want to worry about that. We want to correct it now for you. So I don't think it's folklore. To answer your original question, I think there's some truth in it. I just think you just don't know.
Yeah, this space is just filled with lots of opinions and conjecture that it's hard to really know what's true and what's not. Because you actually mentioned one earlier that came up a lot when the FTC originally made this non-compete ban. And in fact, my hospital and many hospitals came out and immediately afterwards said, hey, we know that you've heard about this, but it doesn't apply to us because we are a 501c3 or a nonprofit hospital. And me living and breathing in the personal finance space for physicians was like, I'm going to go and read this thing myself. And sure enough, it was like page 50 or something like that. It basically said that that's not true, that in fact, the law needs to determine if this is applicable or not. And if you have a hospital that acts like a for-profit entity, even though it claims to not be from a tax status, that law would still apply. And so there was a lot of conversation about that. And you mentioned earlier the for-profit portion of that. What are your thoughts on that?
Well, I thought the page 50 or whatever page it was is maybe one of the best parts for me of that whole thing because it basically says, yeah, you're nonprofit from a tax standpoint, but if you look, smell, and feel like a for-profit company, we're going to treat you that way, and this rule applies to you. And so, of course, they don't like to hear that, but most health systems, right, are not as pure, right, maybe as they'd like to think they are. They're still driving a lot of profit, even if they're a nonprofit entity. So, again, we wish it was in place right now so we could see how that would play out, but maybe it will be. A year from now, we can see what that looks like.
Yeah, it's been really interesting to follow the whole thing. And in 2023, there's actually preceding the FTC ruling, Marco Rubio, a Republican, and Maggie Hassan, who's a Democrat, introduced this Freedom to Compete Act, and this has bipartisan support. It is something that obviously the wide swath of human beings that this would affect support. And so do you think that anything's going to come of it? Let's say the FTC thing doesn't work out. Do you think constitutionally something's going to happen there, or do you think it's going to be the states' rights kind of thing, like you mentioned earlier?
Yeah, I think it would be tough at a federal level to get a big blanket like this, because I think there are certain examples, right, in certain industries where they tend to make sense, right? If you're turning over client lists, right, like a salesperson, I think it makes some sense to protect the business, right? You guys have reputations, and don't walk across the street and steal all of our clients. Healthcare just feels so different, right? These aren't clients; these are patients. It's serving, right, a bigger, larger public good than just a sales role would be. And so I think if they would dial in what they're trying to do, and maybe take a small step first and say, hey, let's make this about healthcare, I think you'd have a lot more success, because that might lead to other, right, occupations as well. A lot of the states have started, right, that process. I think they've seen the attention on this, and they're starting to say, okay, maybe healthcare workers should be exempt, right, from our non-compete rules, or maybe there should be limitations. It can't be more than 10 miles, something like that, because you're right. Most physicians don't want to move. I mean, they're like everybody else. They got kids in school, and they've got spouses that are working in the area. And so it's, with the consolidation in healthcare, it's not like you have 50 options in a city anymore, right? I mean, it's like you've got 5, right, or 6 at most. And so I just think we've got to adjust as the industry's changed.
Yeah, I mean, I've gone through this myself. Obviously, over the last 7 years, there have been times where I've, like every doctor, looked at jobs, and I mean, currently my non-compete, and this is interesting because at our hospital, there's obviously a history of doctors. Some people signed a contract 35 years ago, and some people signed a contract last month. And it's fascinating to see the different contracts that have been laid out, from not having a non-compete at all to, hey, there's a cost share. If you leave, it costs X number of dollars, to, hey, you can't work in this county, to, oh, now you can't work in this county, the next county, or within 30 miles of any city that you practice. And so it's been fascinating watching this change, and the different contracts that different contracts that physicians have, which I think goes to the point of what you do at Resolve, right? Is to look at those individual contracts and to make them reasonable, something that both people would be willing to sign. So when somebody has this boilerplate contract put in front of them, because that's often the language that's used, this is what we offer every doctor for this specific job.
Yeah, they're all
Yeah.
standard. Yeah.
Yeah. So what do you say in that situation when the doc's like, they say I can't, there's nothing I can do?
Yeah, well, we say that's what everybody says, because they do. And it's okay. I mean, I don't fault an institution from wanting a standard document, right? To say, hey, everybody is on this one. If I was legal on their side, it'd make my life a lot easier. The problem is, especially with physicians, is you guys are driving, right, 99% of the revenue that's going to flow through that institution. And so with high level employees like that, you generally you make deals, right? You cut out carve outs, you have exceptions. If somebody only wants to work 4 days a week and you really need them, you let them do that, right? If you have somebody that says, I'm not going to come to work for you because I won't sign a non-compete because I've got a spouse here that has to have a job in the area, we're not going to move, all my family's here. Well, if you really need that, whatever, anesthesiologist, cardiologist, it's not like there's a surplus of physicians, right? There's a shortage, right? So there's this supply and demand factor that goes into it. My position is, you should be making adjustments, right? They always should be considering each individual situation, and we do see that happen. So we see organizations change, whether it's comp or language, more frequently than not, right? It's like 80 to 85% of the time they're going to make an adjustment, even to their standard language. Now, procedurally, they may want to do that with an amendment, with an exhibit, right? They might not want to change the bulk of the document itself, but there's lots of ways to skin the cat, right? On that, you can get there different ways. So I do think you should feel empowered. You should understand the value you're bringing, and hopefully you've got a couple options too, where if somebody absolutely says no, right, and they mean it, because maybe they have 5 or 6 candidates, that you've got something else to look at.
Okay. And so let's talk about that a little bit more nitty gritty. If I were an employer, and to your point earlier, you didn't use the term, but you described this like a non-solicitation. So they've got non-solicitations, you've got restrictive covenants within a document, a contract that you might sign for employment. For me, if I was an employer, I would say, hey, look, this non-solicitation actually matters more to me. I don't want you to take the patients that are in our system. I don't want you to take the nurses and the medical staff and everybody that works with you to come along and work at the competitor across the street. And so in some sense, this is still a non-compete, but it's not saying you can't go work there. It's just saying, hey, don't steal business from us. And so do you ever see that the language is kind of pushed more towards a non-solicitation to get away from the non-compete, or are these just two separately negotiated items?
Well, there are two different paragraphs and sections in a contract, and they do have different meaning, which you're hitting on. But I think the problem in healthcare again is that patients really like their doctors usually, and so you're not going to have to solicit. They're just going to go on Google and they're going to find out where you work and they're going to come over. And so the non-solicitations I think are good in theory, but I think patients are pretty smart now. And if they're like, hey, Dr. Turner's no longer at Wake or wherever, they're going to know where you're at and you're not going to have to solicit them. So I think that's why the non-compete is more important for the employer.
Yeah. So just to be clear, I'm an anesthesiologist. Nobody looks me up.
Yeah, yeah, right. Nobody's going to follow you. Yeah.
Hey, if I was a surgeon, I completely get it. Actually, I find this interesting that there are many APP specialties that don't have non-competes. My institution included. CRNAs at my institution don't have a non-compete, while the anesthesiologists do. And I've always found that really hilarious. To your point, like I think that would be kind of indefensible in court, just because like people don't come and look for an anesthesiologist. They're like, hey, I want Dr. Smith to take care of me because they're world renowned at this one surgical procedure they do. And you just get an anesthesiologist that day that you're never going to remember the name of, so long as everything goes well.
Right. Yeah.
We're kind of
Anesthesia, hospitalist, ER. I mean, there's different spots where it's like you're not picking, right? You're just coming in.
Yeah, exactly. I feel like I'm a little bit like a referee in a sporting event. If I do a really good job, no one remembers me. But if I do if I do a bad job, unfortunately, people do remember your name. So, hey, let's talk about non-competes being there. Right? Let's just assume the FTC thing is going to get struck down. The stay is going to move forward. It's not going to exist. Let's say you live in a state that doesn't have a ban on non-competes. What are some successful strategies that you see people use to deal with this? You've kind of alluded to some of them. Is it geographic scope? Is it duration? Do you try to get it removed completely? How often does that happen? What are the moves that docs can make when it comes to that sort of thing?
I think you have to be understanding that if an institution has a non-compete in their document, they're probably unlikely to take it out entirely, right? So you're not going to 180 the situation. I do think you can soften them, and the biggest win usually is the geographic scope. So, if you're prevented from working in a location for a year, it's probably not that much different than 2 or 3 years, right? Because you're gonna have to do something for 12 months, right? So, but if you can limit it from 20 miles to 10, you may open up 2 or 3 employers. And do you want to commute, an extra 15 miles? Probably not, but you will, right? For a little while to be able to stay in the area. So I think geographically, that would be your number one. But there's also other things you can do. You can carve out exceptions for maybe academics, right, or the VA, where they don't feel like that's a competitive institution for your employer. You can carve out how the contract terminates, right? So if they just let you go for no reason or they're in breach of contract, I mean, those should be exceptions to when you don't have a non-compete. If they get bought, there's a merger, there's a lot of M&A action. If you're in private practice, for example, and they get bought out, you thought you were going to be a partner next year, and now that's not on the table. Maybe you want to go somewhere else. So all of these carve outs that are going to be specific, right, to your situation can help, right, lessen the impact of the non-compete, even if you can't get it taken out entirely.
Yeah, I've seen docs that have definitely gone and traveled and worked locum shifts for a year or two in order to deal with their non-compete because they didn't want to move their family. And obviously that's a big deal. I mean, that is unsustainable, and, but it's something I've seen people have to do because they didn't successfully negotiate their non-compete. And I guess I should say while we're recording this show that when I signed my contract, I knew nothing about personal finance at that point. I signed it before my fellowship, which is the year that I really dove into this stuff. And now, like looking back, I find it obviously very interesting. And I wish I had had somebody review my contract, but didn't even cross my mind back then. So for those of you that are listening, and you're like, well, I have a non-compete and this is not exactly great. I commiserate with you. I empathize with you, and it's okay. So, hey, why don't we move on to a couple other contract items outside of non-compete, non-solicitation. Intellectual property. This is something that kind of comes up a lot. I'd love to hear your thoughts on intellectual property pieces to contracts, why they're important, if they're important, what to do about it.
So they're either for our clients really important because people love this stuff. They're constantly tinkering and generating reports and all these different things that they want to have ownership of. or it seems like it's the 180. They just absolutely don't care. They're like, I'm never doing that. I don't have any patents or devices that I need to protect. So I think if it's important for you, I think you absolutely need to pay attention to the contract on that section, because most are going to start out saying the employer owns everything that you do, everything that you create while you're an employee. And that's obviously not good for things like this podcast, right? I mean, you want to make sure that you're owning this and that you get to keep any side gig that you're working on, that you're allowed to do side gigs, right? But even beyond that, if you're just doing research, you're creating something of value outside of academic institutions, right? We think that should be 100% yours. Within academics, sometimes you're utilizing, right, their name, their brand, you're getting funding, something where you're going to be splitting ownership on that, and that's a little bit more reasonable, and those percentages can change. But it's more and more common that clients have an interest in doing something outside of medicine, and so you really need to be careful on that.
Yeah, I'm looking at this further. When I started the Physician Philosopher, it was anonymous, and so I was blogging 3 days a week. I didn't ask for permission on it. I was doing this thing, and honestly, it was me working 20 hours a week on something that made absolutely zero money. And so at the time, I didn't really feel the need to disclose it. And I would later write a book, right? The Physician Philosopher's Guide to Personal Finance. And when I wrote that book, I wanted to put my name on it. I didn't want it to be anonymous. And so I sat down with my chair and I was like, hey, what if I theoretically had this book and this blog and all of this stuff? What would you think about that? And they were actually really supportive. And the policy, and again, this is so fascinating to me as things change with your employer, but the policy at the time was like, hey, you just need your chair's approval. And so I got my chair's approval and I was like, hey, this is great, right? I'm just going to keep doing this thing. And then they had a conflict of interest policy kind of come out and they're like, hey, we need to disclose things if it's in the realm of medicine and you're working with people in medicine. So I disclosed it and it got approved every year. And now it's basically like, hey, do you do anything in medicine that is medical in nature that will impact patients? And so specifically medical. And so I don't even have to like disclose it this year because by their definitions, what I do doesn't meet it. And so you do have to kind of keep up with the policies and the contracts, but that makes me ask the question, right? You've got the contract and you've got policies that your hospital implements. And those are two different things. So when it comes down to policies, is it carte blanche, like your contract's like, hey, you got to follow our policies if you're employed by us, and therefore these policies are an extension of the contract? Or are they separate because you signed a contract but didn't have any say over the policies? How do those two things work together?
It depends. So most contracts are going to be drafted to have that first example, right? Where we're going to incorporate every single policy that we have. And so we're going to change those on an ongoing basis. But, if there's any gaps in that, right, the contract is going to govern. There are some contracts that say the employment agreement wipes out, right? If it contradicts at all with a policy, we go back to the contract. And so I think you've got to be really careful on how what you're signing has been drafted. The areas, intellectual property is one of them, right? But the more important policy that we're seeing is compensation plans, right? Where they'll say, we're going to pay you X number of dollars for the year, but then we're just going to have this comp plan that comes in and we're going to adjust that from time to time. Boy, we don't like that. We want to make sure we know what you're paid. And if they want to increase it, great, but we don't want them to take it down, or at least not down very much. And so that's more problematic, I think, than even the other more kind of benign policies that are out there.
Okay, that's fair.
Yeah.
So you got a doc. They're like, hey, Kyle, I want you to review my contract. You look at it and you're like, this is a hot, stinking mess. This thing's a piece of garbage. There's 47 things in here that you want to address. And let's say that doc really wants to be in that area, right? And from their standpoint, like their their alternative to no agreement is not great. Like it's the one place, it's the one gig and that one hospital. Yeah. But that these terms aren't great. Obviously, one choice is just to say, hey, suck it up. Like they're going brass knuckles, brass tacks there. Like it is what it is. I find that doctors often don't realize how much leverage they have when they negotiate. And so you mentioned the shortage earlier. So with that knowledge, knowing that hospitals need doctors and they need doctors in the specialties that are looking to get a job and they have the contract in front of them, how do you encourage docs to negotiate and to use that leverage when they don't realize how much leverage they have?
Yeah, but it's the how much risk are you willing to take conversation, right? Because is there a risk that somebody else will come in and steal that job from you? Of course, there's some, right? Is that risk very high? No, right? It's just like in medicine, like anything's possible, right? There's always this edge case that's out there, but most of the time they need you. They don't have a lot of options. You generate a ton of revenue for them, right? Whether it's in your specialty or downstream or in facility fees or something else. And so I think the more educated, right, physicians are on just the economics around the situation, the better they'll feel about it. But that being said, if they have to be there, right, it's their only option. Nobody else is hiring. I mean, just as a person, right, I get that. If I had to be in a spot where all my family was, I wouldn't push as hard as if I had 10 options and they were all good options. So I think what we do is we're going to identify those 47 or 20 or however many issues we see in the contract. We're going to help walk you through why we think they're important. But you, as our client, are also going to have to prioritize. And you're going to have to say, yeah, I know maybe my work RVU rate's a little bit low, but I don't want to push on that as much because I'm really happy with the base salary. I'm really happy with the call I'm getting or some other term. And so I think you want to advocate for yourself and pick your spots in that situation and probably not push on every single paragraph, but pick the 4 or 5 that are most important to you. I do think that's easier the more, I guess, empowered you feel, right? Meaning the better understanding of the entire situation that you have, which is what you mentioned earlier. So I think try to educate yourself as early and often as possible, and hopefully you'll go in with a little more bravado or a little more, confidence in what you're doing.
So I got to ask you, I'm a big fan of this book, and so I'm just going to mention it. And if you hate it, please tell me. But I have to ask, right? So I'm a big fan of Chris Voss's book, Never Split the Difference, and use a lot of the tools in that book in many aspects of my life. So I'm curious. We look at the contract, we see these 47 things that aren't great. We come up with this list of 5 or 6 that are really important that we need to address. How helpful do you find those tools that are taught in that book to actually go through a negotiation with somebody?
I think they're helpful. I think there's certain times when negotiating, like, he's talking about where it's going to be a little bit different. I think medicine is so unique in the fact that they have to have you, right? That it's and they want to know if you have other options, and you also have to be talking to the right person. So I think those tools are helpful. I think getting to the right person is as important though as any tactic, whether you're sending an email or a phone call or how you're delivering the message. Because if you've got the wrong person that you're in front of, it's not going to matter. So we know physician recruitment, their job is to get you in to pass the contracts around. Most of the time, they're not the ones making the decision, though, on this, right? It's going to be your chair. It's going to be, somebody, a CEO of a hospital. And so I think communicating the right way at the right times to the right people, if you can match all that up, I think that's what's most helpful. But I also think you need to be efficient, right, with your time and with asking for these things. And so we encourage everybody to say, hey, if you've got 13 items that you have to talk about, let's make sure we get all those out there in that first draft. You don't want to piecemeal it and come back later on and say, okay, well, now that we talked about comp, now let's talk about tail coverage. Now let's talk about the non-compete, because they get real frustrated real quick, right, with that type of strategy.
Yeah, I had a negotiation one time where I missed something on the first way through and came back, and we'd agreed on everything else, and they were not happy. This wasn't with my hospital. This was entrepreneurial related. And I felt bad, but I was like, hey, look, this is like a non-negotiable thing for me. I don't know how I missed it the first time through, but didn't notice the language, looked at it. And I was like, I can't sign it with this there. And they came back and they signed it because they realized, like, hey, what he's asking for is really reasonable. But that additional time, because I didn't lay it out there the first time, was, they weren't happy. So options, you mentioned this, you mentioned talking to the right person. So how do you find the right person, right? So like, let's say you're on the side of the negotiation. How do you find out, like, is it this person I'm speaking to? Is it the next person up? Is it the chair? Is it the CEO? How do you determine that?
Well, we always recommend that you go back to whoever gave you the contract first. So don't jump chain of command, right, without starting the process the right way. So I do think if it's recruitment or a business office that's sent you the document, go ahead and go back there. But I do think getting to either the chair is the right type of person, right? The leader of the division, right? Whoever that is. That's one person. Legal's another one, right? So there's some questions that are just purely for counsel, right? It's a language issue, or the CEO. I mean, those are the best spots for you to end up, especially on things that are deal breakers, because that's who's going to have the authority to make the change anyway, right? So if you give it to anybody else, they're going to just pass it up the chain. And so start with the entry level, right? Start with HR, recruitment, whoever gave you the document. And then based on the issue, right? If it's a language issue, probably legal is the right person. If it's a financial issue, it's probably the CEO. If it's a scope of work, right? Call or something else, right? I mean, that's more of a divisional issue. So I think it's finding the right spot between all those based on issue.
Okay, that makes sense. And it seems like you'd want a single point of contact. So it might end up
Yep.
being the chair, the division chief,
Mhm.
whoever it might be in that situation. And they're going to go ask legal and come back to you
That's right.
and that sort of thing. And I have had situations in negotiations where the two lawyers on the two different sides didn't really agree. And there was lots of back and forth because it was lawyer A to person B to lawyer B.
Yeah.
And eventually, and I'm talking about myself, by the way, right now. And
Yeah.
I eventually I just had to say, hey, you two lawyers, like, go talk to each other, go hash this out, go have a conversation because this is completely inefficient. I don't know how that happens a lot in the entrepreneur world. How often does that happen where you have to go talk to the legal counsel for a specific person or your company? Obviously, it might not be you.
We talk to them all the time. So when we're helping clients out, I mean, it's fairly common for an institution to say, okay, you have representation. We now ethically, right? You're supposed to talk attorney to attorney, not attorney to client on the other side. So that happens a lot. And I actually think that's a lot of clients like that. They want to step out of it and just say, hey, come back to me when, you've done some of the heavy lifting for me. So I actually find too that in-house counsel for the most part are fairly open and receptive, right, to language changes and things. They may not be able to make it, right? Sometimes it's institutionally they made a decision where their hands are tied, but if you're going in with reasonable requests, they're not going to be offended by it. They may say no, but they won't be offended.
Okay. One other piece I wanted to cover that's talked about, but I want your view on it is tail coverage. Right. This is something that happens all the time, and people don't realize until they're in that situation. Like, I'm fed up with this job, and I'm going to go do locums for 2 years so that I can come back because I had this terrible non compete in my contract that I should have competed. I should have negotiated to have changed, but I didn't. And then they go to leave and they realize, hey, you got to cover your tail for all the stuff you've been doing at that institution before you left. So talk to us about tail coverage. What is it? Why is it important? And how often is that something that's successfully negotiated in a contract?
Yeah. So why it's important. So patients have a certain amount of time to file a claim, right? It's called statute of limitations. It varies by states, usually between 2 years and if you're in pediatrics, a long time, right? And so because we let kids get out of their parents' oversight and let them decide if they want to sue or not. So what it means is you got to have coverage for at least 2 years, maybe 20 years type of thing. And that's problematic, right? There's a cost that goes along with insuring you for that amount of time. Some policies are going to cover you on an occurrence basis, meaning they're covering your actions, and it doesn't matter when the lawsuit comes in. A lot of employers will go for what's called the claims made policy. They're only going to cover claims that are filed while you're working there. And so if there's this gap in time after the fact, that's what tail is, right? You got to cover it. So we often view those, depending on your specialty, as a kind of a similar amount to a signing bonus, right? It's going to be 2 times your annual premium, and so if it costs you $10,000 to insure yourself, it's a $20,000 bill for tail. And some specialties, like if you're in OB, it can be really high. It can be six-figure numbers, right? So that's really problematic, and you don't want to miss that. So your goal in your contract is to drive as much of that cost to your employer as possible. Be great if they covered all of it 100%, but sometimes they don't. Sometimes we'll see them vest into it, so you get kind of credit over time, like a retirement plan, where if you're here for a year, we'll pay for a third. If you're here for 3 years, we'll pay for all of it. That type of scenario. So you can be successful on it. It's just a value point, right? It's not a major language change or anything like that. It's mostly just how many dollars are we willing to stick behind this. We've seen people solve it by either paying for tail, maybe giving a retention bonus, maybe giving an increased signing bonus, different ways to, again, skin it, but certainly important and not something you want to be surprised by when you leave.
Yeah, and I think ultimately the take-home point, whether it's tail coverage or IP stuff or the non-solicitation, non-compete that we started with, it's really important to have your contract reviewed. And Kyle, you guys at Resolve have been awesome. And so if people listening to this podcast, listeners listening to this podcast, want to get a contract reviewed, go to moneymeetsmedicine.com/resolve. And there's actually a code that Resolve, Kyle, your team is amazing. And so he gave us a 10 off 10OFF, and that gets 10% off a contract review if they go to Resolve. So if someone's stepping into that process, they want to get their contract reviewed, what does that look like?
Yeah, so first step is what you just said, right? Go to the site, get the discount. We want you to do that. We're fairly transparent and as tech heavy as we can be, right, in the legal world. So you upload your documents on the site. You're going to get some instant analysis and some compensation numbers that you can look at. You're going to schedule a call with an attorney. We're going to go through everything we just talked about, right? We're going to say, hey, what's your situation? Let's make sure we get this customized for you, and we'll turn around a document back that says, here's the suggested changes. Depending on level of service, we might negotiate for you. We might look at 2 or 3 different offers. There should be hopefully like a something for everybody there, depending on what you need. And so we try to do that fairly quickly, usually within a week, right? You'll hear back from us. And so it's what we're passionate about, right? It's why we're here. It's kind of what we do all day. It's like our specialty. So if you guys are in that spot of need, we hope you check us out.
I appreciate that, and look forward to hearing good news, like I always do, from people that go over to Resolve to get their contract reviewed. And Kyle, as you're talking, I'm gonna throw in like a last second question because I just thought about this.
Yeah.
And I've had this successfully negotiated for a lot of my residents. Partnerships. So you mentioned vesting and the idea of like being there X number of years for tail coverage, for matching for your 401k or 403b. Talk to me about like the idea. It's not called vesting, but in that area of you're on a partnership track, and this is, I don't know if this is germane to every specialty, but in my world, it's very germane, where someone's like, hey, 2 years, you stay with us, you'll be up for partner, or 3 years, you'll be up for partner. And in the world of private equity and everything getting bought up and practices going from truly private practice to no longer being owned, and the partner's getting a massive sum of money for doing so, the person who's like 2 years and 300 days to becoming partner, talk to us about negotiating that aspect of things, what you've seen there.
Yeah, that story unfortunately happens a lot now, right? Where the more senior folks are cashing out, right? Because they're kind of seeing the writing on the wall. Private practice is hard, and it's not great for the person that's been there 2.5 years. So what we would encourage you to do is to upfront have some type of protection for yourself, whether that's a trigger on becoming a partner, right? Like an option to accelerate if there's a purchase, or get treated like a junior partner, right? Where there's some smaller payout that you get for your time that you've been there. Certainly you want to have your tail paid for. You want to be released from your non-compete. You want to be able to break, right, cleanly if you need to. But on top of that, financially, we'd like to see you accelerate, right? And kind of vest into the partnership if there's a sale. If there's not a sale, right, it doesn't matter, right? It's like an option that just never gets exercised. So it's only for that worst case scenario planning. In my experience, the private group practice groups that are least likely to sell are the most likely to put that language in. So because they're like, yeah, it's a nothing, right, for us. If you're asking for it and they're really pushing back, going, no, we can't do that, they may have had some talks, right, about M&A action, and it might be more realistic than what they're leading on to.
That's exactly what I tell my residents. And in the flavor of Chris Voss, since we mentioned him earlier, I'd say like, hey, point out the problem. And I tell them like, yeah, they got this boilerplate contract they gave me, and they say that there's no way that they're going to get bought out, so it's not a big deal. And I said, why don't you just go back to them and tell them that exact thing? Hey, you say this is not going to happen. There's no way this is going to happen. So if that's the case, you surely wouldn't mind putting this language in there, right? And the majority of the time when they're actually being forthright, they put it in the contract, and my resident will come back to me, and I'll be like, hey, how'd your talk go? And they'll say, I can't talk about it. I'm like, okay, are you happy? And they're like, yes. I'm like, okay, because they don't want the whole world to know that they successfully negotiated that into their contract. But there are times where people come back and say, hey, they aren't going to let me do that. And I'm like, well, that's a pretty big red flag. And if you're okay with knowing that that's possible in the next 2 to 3 years, you can sign the contract, but just recognize when they do that 2 years from now, don't be surprised, right?
And we like the eyes wide open part, right? Is the contract going to be perfect for you? Probably not. I mean, there's always things that, each side kind of wins on, so to speak, but you certainly don't want to be surprised by it, right? You want to make sure you know that you don't have tails, so you're setting aside some funds to do that, or you're negotiating in your next contract. You want to know what your non-compete is. So all these things are really important, and I love when people like you are also educating residents on this, because there's not a lot of it, right? I mean, there's not a lot of business training in that process. So we're all about people that are doing that.
Yeah, excellent. Well, Kyle, thanks for coming on. And for those listening, you can go to moneymeetsmedicine.com/resolve and use that code 10OFF, so 10OFF, to get 10% off at Resolve for a contract review. Kyle, thanks so much for coming on the show.
Appreciate it.